by this batch. Not by this.
I have no idea, but
Not this court of particularly I had appeared to the council.
oh,
Long time back.
let it come in the month of January.
Let it be listed normally. We will not like first.
May I please, your lord. My lord, with the consent of the other side, my lord, I beg to mention item number 5 of list honorable bench, division bench 1.
Yes.
My lord, my senior Mr. Visidas will argue in this case, but he is suffering from flu take, my lord.
Okay. 21.
After 2 weeks, my lord.
On a prayer made on behalf of appellant. Matter is adjourned. Yes.
Deeply, your
May please, your lordship. My lord, with consent of all the parties, my lord, I beg to mention item number 4 of the daily list, my lord.
Yes.
The conducting also Mr. Pritam Mahanta is out of session, my lord.
18 matter. 21.
After a week, my lord.
It is submitted that P. Mahanta, the Senate Council conduct is on behalf of the appellant out of the list after a week.
My lord.
Other side informed.
I have informed all the side, my lord. I love bless.
May it please, your lordship.
Yes.
Lordship, I am praying for listing of the unlisted writ petition on tomorrow, my lord.
Read petition
Yes, lordship.
for the
Petitioner
division bench.
division bench 2, lordship.
You have to mention here.
Yes, lordship. As per notification,
What is the urgency?
lordship, petitioner is a senior citizen under detention center since 31/10/2023.
3110.
Yes, lordship. So maybe on taken on tomorrow, lord.
When have you filed?
24/11, lordship.
2411.
Yes, lord.
Have the 30th come?
Deeply obliged, lordship.
Have you served on the other side? Have you served copies on the other side?
Yes, lordship. Deeply obliged, lord.
May it please, your lord. Lord, I beg to mention an urgent writ appeal, my lord, for listing tomorrow. The direction of the learned single is for carrying out.
For admission.
Yes, my lord.
First time it will come up.
My lord.
Why? What year?
My lord, a day after tomorrow has been fixed for the date for measurement and eviction, my lord. Well, the question is whether 3E of the National Highway Authority Act will apply, or, my lord, the control of 2002 Act, by which there is a provision for issuing.
Ultimately, you will be entitled to compensation. How to stop
Lord,
the eviction or your removal?
My lord, that is not the issue. Issue was, my lord, when the land was acquired, my lord, no measurement was carried out, no notices was issued. There was a stay order by the learned single judge, my lord. Thereafter,
Okay.
my lord,
May I please, your lord. Lordship, I beg to mention for listing and writ petition, your lord. Here,
For whom?
your lord,
Petition for whom?
DV2, your lord.
What's the matter about?
Matter, here, your lordship, petitioner was taken into custody on 30/11/2023, your lord. We have filed a writ petition on 16/11/2023. It is yet not from your lord.
By tomorrow.
Your lordship,
Have it on Friday?
yes, your lord, we have filed.
When do you want?
Tomorrow, your lord.
I have it on Friday.
Your lordship,
Friday.
Friday. Lordship, petitioner is in custody, your lord.
You have filed already on 16th. You have not moved till now.
Yes, it was not come up. Your
You have moved and mentioned memo. This is a very temporary kind of a bench.
lordship. Deeply obliged.
Pleases your lordship. Lordship, I pray this matter for stay vacating order on Friday,
You have filed application for stay vacant.
Yes.
When have you filed?
21 November. Thank you.
My lord, as per the last order, my lord, last opportunity was given to respondent 8, my
Lordship will file the affidavit today, Lordship, in the courts of
You will file it.
for respondent 8.
Lordship for response.
Sri B. Barua, Senate Counsel for the appellant submit that the last opportunity was granted for filing affidavit by the by MS
People
B. Barua, Senate
appearing on behalf of Mr. Deepnath.
Counsel, represent respondent by 8, however, submit that the affidavit would be filed during the course of the- after the week, along with the that filed.
Deeply object.
My lord, there is an IA filed by us for vacating the interim order, my lord. Here, what my lord, the petitioner, here the applicant was in this IA was transferred, which is the respondent three in the writ petition and the appellant in the writ appeal to Longding, my lord. On my lord, 24/7/2023.
Mr. Das is for-
Lord, I am for the writ appellant. Lord, what happened
for- in your appeal, there's stay out,
there is a stay.
which she is praying for vacation.
Their contention is that, my lord, that after the interference of this honorable court, my lord, the applicant, he is hanging because government of Arunachal Pradesh is not sending him or posting him to his original place of posting. That is their contention. Lord, you will kindly have a look at the last order passed in IA.
Mr. Sharma, what do you want?
My lord,
You want a clarification of the order? You want some
no,
action
no,
from
we
the
want the order to be vacated, my lord. I have already joined, taken up charge, I have released from there, and I have shifted lock, extract and barrel, and there is no ground for him, my lord, because
Okay,
the
okay, understood.
government will has filed the affidavit, my lord. There are lots of kindly go
No,
to
no,
me.
let me hear him, the petition. This petition.
Lordship, because Lord, subject to my lord, what my senior says, by order dated 8/11/23 in the
Yes.
IA passed,
Hmm.
if your lordship kindly have a look, it says that
Have you filed the affidavit?
We filed the affidavit. It does not come on that. We filed on 23rd. But 24th was the only open day and after
Okay. I think we'll have this tomorrow, day after, that the affidavit comes.
Is that day after, my lord?
in the
Yeah.
main writ appeal affidavit has not been filed.
Doesn't matter, we
No,
will
no,
go
no,
by the
no.
order of 8/11,
This may be
which
treated.
directed the government to file an affidavit.
Yes.
Third. PRP Sharma, the senior counsel for the applicant. I've also heard Sri K. Das, learned counsel appearing for the opposite party petition. Sarah? Sri B.D. Gusam, learned
1 and 2, my
KOD AG. Learned AG, Arunachal Pradesh. However, that do pursuant the order to 8/11/23, an affidavit has filed by the department of the same has not been tagged with the record. Submit that such affidavit was filed on 23/7/20 as agreed by the parties from on 11 6 on 5 along with the affidavit filed by
Mr. Das will furnish me a copy of the writ appeal, my lord.
you have not
I took steps, my lord, I'll file one issue, my lord, no issue.
they are not
No issue, no problem.
Abulai,
otherwise your affidavit copy has been served on both of them.
I have got. I have got.
I have got
They
the copy.
They have stopped the copy.
started your friend employer the one more copy.
No, I have got. Your copy.
No, that
For writ appeal. No, we have not got.
Rather, he doesn't have any space.
My lord.
It'll be difficult for him.
And lords will be surprised to see every day changing juniors.
Highly obliged. Lordship was taken a fixed on Friday, my lord.
Right.
Highly obliged.
My lord, here we have challenged the violence of the rules. Now, only thing is, my lord,
Mr. Dekka,
he otherwise appears as sending counsel.
let- let- not
Even we thought, my lord, since it's not a regular bench, it will take some time also.
this for any other one of the having the
Sir, it may be fixed on any other date, my lord. I did not prepare because it was fixed before another court, which was
on the prayer of PPT the Senate Council.
But now,
And
but
PPT
honorable
the
Chief Justice is no longer there, therefore it can come before any bench.
any bench.
was it checked?
No, nothing like that. But the honorable
It was
Chief
hard
Justice
in
did
detail before the, by honorable Chief Justice, but it can be done.
PPT the Senate Council. This for some. The case will be done in council. For this number
I am for the respondents,
Private respondent.
private respondents.
6, 7, and 13.
Yes.
Also heard. On as a by department.
My lord, can it be day after tomorrow, my lord, because we are without job, my lord. Because although we are appointed,
My lord, next week, any date. Next week.
no, no, next week I'll delete it from the
Thomas from Hemant or
তুমি আর করা হবে।
Monterey brief on a date of.
তুমি তো করা হবে, হেমন্ত এদিন মই দেখা নাই।
My lord, let
Let it be day after tomorrow, my lord, because we are without, my lord, any posting.
The Chaudhary, the Senate Council, however, is take into account the efforts of this after
Yeah.
Very detailed order will have. APSC will produce the record.
Yes, sir.
APSC may produce the record.
Yes.
records are there. Yes.
Although not original, my lord, original in the hand of.
No, it was produced last time.
Whatever is there,
Yeah, whatever.
it is item 8 and 9. 8 and 9, your matter.
Lordship, the Advocate General appears in this matter, Lordship.
My lord,
Well,
I
Lordship, he has
appreciate
some
today there is a match is there.
Lordship.
So my lord, there, this matter also may be taken up there. I don't dispute that today he'll be busy.
Are you to pick?
No, well, I'm not.
Prayer.
I think on that count, they should provide me a pass for
That's not
accommodating them.
Not out of the.
Anyway, if I make a request, definitely they will give.
The people.
Poroki.
Will appear is what they have get and praise for retain certain elected by the party. After
Deeply
Lordship,
object.
in the item number 9, Lordship, I am appellant here.
in act, but is yes for W 291.
Yes,
Deeply object.
Both are connected.
Connected.
Item 10. SP Laskar. Air Barua. Indian Oil Corporation. Sharma. IOC. 10, item 10. What is Mr. M.K. Sudhri appeared in this case? My lord, it has not been allowed. Non-appears participant for
I'm very good.
non-appears for appellant. However, MS RP for a state council present for the for the deputy. To the
Lordship's father cannot take up this matter, my lord. 11, my lord. Against your lordship's order.
This for any other bench without one.
Deep lord.
Hello, my name. Enter Soman.
This is an application against an award, my lord. Passed by Industrial Tribunal, Guwahati. My lord,
Other side. P Sundi. Aware of
I'm not there.
that's the habit of sometimes because there
Yes, ma'am.
benches of at 2 o'clock, he may not get. We much up. We come to have it, otherwise cannot. But please be there. We come. Full man.
Lordship, matter may be fixed at 2. My senior has some personal difficulty.
Contempt is still surviving cause of action.
If the matter has become
Infrastructure. And why wait for a close this? Have you got instructions from your senior or not?
no, Your
Then how do you know it's the instruction? Ask your senior, we'll have it after. Ask your Item 5. This for admission. Careful. You're there.
I'm looking for JMDA, my lord.
You're not recording or
I-
even step. It's up. If you
Publish.
will have the answer.
My lord, the respondent number 7 has filed an affidavit to which we have filed a reply today. Can it come along with the affidavit, my lord?
Actually, my lord, there is a stay order operating. Can it be there after tomorrow?
Let it be Friday, my lord. Has the already lordship has picked 50 matter.
For the petitioner,
Yes, my lord.
submit that the rejoinder of it has been filed today, which however not the accepted was also a for the
Respondent of 500
what prior to respond, whereas 6% appears for the AIDC.
Yeah.
As agreed to by the party, is on Friday.
Right.
Along with
Along with
along with
the affidavit.
affidavit.
Yeah, please, Your Lordship. Lordship, I am appearing on behalf of S. Dr. Lordship, instruction is not received. Instruction is not received, Lordship. Stand for waiting, Lordship. So kindly sort it maybe.
Thought that may be given, my lord, because I was the highest bidder, my lord.
Okay.
Because
Third, Priyank Sharma Nanak Count. Sir, Empora.
K. Bora, Lordship.
Ms. J. Bora Nanak Council appearing on instruction of S. Dr. Standing Council cannot, however, submit that the affidavit has sent for and by after 2 weeks.
next week, my lord, because you're a last
Can you
month.
file next week?
Lordship.
We'll pick the date then.
Yes.
This on. We'll have it on 7th of
God bless the Lord.
May please, Your Lordship. Your Lordship, the gist of the
already filed affidavit.
yes, they filed the affidavit. But the gist of the matter is that Niramek, Your Lordship, is like is a platform where different agricultural providers are impaneled. The petitioners, Your Lordship, were
We
impaneled.
can take this for disposal.
Lordship, here, the termination was done by the NERAMEC, not the agriculture department. Lordship.
Naramak has been served on.
Yes, Your Lordship. In fact, they appeared also. There's a dusty affidavit also which I've served, Your Lordship.
Anyone has appeared.
Yes, Your Lordship. On the last occasion on 2011-23, Your Lordship, the counsel for Niramek had appeared. I think they're probably a little delayed here because
We will wait for some time.
Yes, yes.
Otherwise, we'll pick up the affidavit.
yes, I'm grateful, Your Lord.
Try to locate them
Yes, yes.
because of the confusion.
My senior is on it. Oh, Niramek? Lordship, my friend is here for Niramek.
Yes.
Sorry, sir.
Yes, doesn't matter.
Yes.
Take up for disposal.
Yes, sir. Yes. I want to go. The petitioner, Your Lordship, is a licensed distributor of insecticides and pesticides. There was a tender, Your Lordship, which was floated by Niramek for impanelment of agricultural input provider. The tender, Your Lordship, will find at page 26, but that is not subject before Your Lordship. What had happened was, by a communication dated 30th of June 2022, if Your Lordship can kindly come to page 46 for a moment, Your Lordship. Page 46. Page 46. If I may permit it to read, Your Lordship. With reference to the above, in response to your
36.
46, Your Lordship. Page 46.
36. Letter.
Page 46, Your Lordship. The letter dated is 36/2022. With reference to the above, in response to your EOI submitted, it is hereby intimated that your concern is found to be substantially responsive and fulfill the criteria and impaneled as a business associate for procurement and supply of agri-horti inputs.
There was a night period.
Yes, yes, Your Lord.
What was the date?
The date of the tender, Your Lordship, is
13
at
or
page
13/5.
26. Yes, Your Lordship.
Page
Page 26, Your Lordship.
13/5.
13/5/2022.
UI.
Yes.
Expression of interest.
Yes. Thereafter, on page 46 is my letter of impanelment. I was impaneled for a year Thereafter, at page 47, your lordship would find there is a clause for extension of empanelment subject to the letter which was served on me. Considering
Where
page 47, your lordship.
letter
Yes,
extension?
extension
Initial was for how
for 1 year. It was for 1 year.
47 is the extension.
Yes. Page 47 is the extension. Now, considering your performance in the last year post empanelment as a business associate for procurement and supply of agri-horti inputs in the northeastern region and other states, we are extending the same for a period of another 6 months till 31st December 2023 on the same
6
term.
months, not 1.
No, this is the extension is for 6 months. The initial period was for 1 year, your lordship. Yes. For a period of another 6 months till 31st December 2023 on the same terms and conditions. You may please acknowledge the letter and confirm your interest in the same. Your lordship, this is the line where the entire crux of the matter lies. Here we were not directed, we were not mandated, we were not obligated. So we were given a discretionary power to acknowledge the letter and confirm our interest in the same. There was no outer limit pursuant to which our response should have reached Neramac. We did not do that. I have to be fair before your lordship. We did not explicitly confirm our interest for empanelment. Your lordship will then kindly come to annexure I, page 48 and page 49. Page 48 and page 49. Yes, your lordship. The subsequent immediately to next pages. Thereafter, we had approached Neramac by way of 2 letters stating that we need certain details of the items included in said segments of pesticides and chemicals, and also the fact that we are not able to access the website of Neramac. We did not confirm the letter per se, your lordship. I have to be fair before your lordship. We did not because there was no mandatory requirement. But page 48 and page 49 shows.
Yes.
Thereafter, at page 50, your lordship, is the impugn termination. Subclause 2, your lordship will see. Please note that as per our extension in Neramac letter, a bid for extension of empanelment as business associate, no acknowledgement mentioning your interest in the same has been received as clearly mentioned in the letter. According page 50, your lordship. Page 50. Yes, your.
23.
Yes. 23/8/2023.
Yes.
Yes. So this is the crux of the matter, your lordship. And the fact. Please, your lordship.
This did
Yes.
this note.
Sir, refer to the letters a bit. Please note that as per our given our extension in Neramac letter, a bit for extension of empanelment as business associate, no acknowledgement mentioning your interest in the same has been received as clearly mentioned in the letter. Accordingly, your extension with Neramac is null and void. At page 47, your lordship, when we were initially extended for a period of 6 months, which was based on our past performance, the requirement to acknowledge and an outer limit for conveying our acknowledgement was never laid down in the letter. Thereafter, we had approached Neramac with certain queries on dates which preceded the impugned letter of termination. But those 2 letters, your lordship, were not construed by Neramac as our willingness to continue. We were impaneled for a period of 3 months thereafter, and suddenly on 23/8/2023, your lordship, we were terminated. As per Section 5 of the Indian Contract Act, your lordship, a proposal may be revoked at any time before the communication of its acceptance is complete as against the proposer, but not afterward. In this regard, your lordship, I humbly submit that there was no mandatory or obligation for us as per the letter itself, to have conveyed our willingness to have continued as an impaneled associate. Our empanelment was not based upon our confirmation, but our empanelment was based upon our past form, which was taken into account.
Not empanelment.
Extension. It was
Empanelment was
yes.
already
I
done.
was already empaneled in 36/2022. The extension, Your Lordship, was based upon our past service that we had rendered.
But we won't that amount to a proposal.
That was a proposal which we answered by way of the two.
Your answer was in August,
Yes,
17th of August.
17/8.
70. You say that there was no outer limit.
There was no outer limit.
But understood. But before you could, even if terming your letter of 17.8 to be a kind of a confirmation.
Yes.
When you had asked for the 8.
Yes.
You say that 23.8 has been issued after that letter.
Yes.
So, even assuming that there may not be any express confirmation, 17.8 can be considered to a kind of confirmation since
Yes.
you had asked for the details.
Yes, because I was
And once
following.
you have accepted the offer,
Yes.
the contract becomes the binding contract.
Yes.
So you cannot just simply resign it.
That is my submission.
Cancellation.
Cancellation also, Your Lordship, has to be based on certain intent of the letter which was issued. With due respect,
You said it was a confident contract.
the exchange of communication between the parties were complete. Maybe
So
not.
let us see your 17.8 again.
Yes.
We'll have some
Yes. Yes, Your Lord.
no,
46,
not 48.
8 and 49. With reference to the above mentioned letter, I'm reading page 48, Your Lordship.
Yes.
With reference to the above mentioned letter, it is to inform you that we have fulfilled the criteria to be empaneled as business associate for the segment, namely pesticides and chemicals. In this context, we request you to kindly provide us the detail of the items included in the said segments for which you have empaneled us as a business associate. Hope you'll oblige the above and do the needful from your end as early as possible. Yes, next. With reference to the above mentioned letter, it is to inform you that we have fulfilled the criteria to be empaneled as business associates for a specific segment along with a few other companies. In this context, we request you to kindly provide us the details of the other companies who has also empaneled for the same. It is also inform you that we are unable to explore the site of Neramac for the last few months. We hereby request you to rectify the same from your end at the earliest so that we can avail the benefit of the same from our end. And there is a background as to why those two letters were written. What happens, Your Lordship, is that Neramac is like a food application. There are vendors on the other side, like the petitioner, and then there are customers like us at the other end of the spectrum. So customers who have a certain need for agricultural inputs, including horticultural inputs or pesticides or chemicals, they send their demand to Neramac. Thereafter, Neramac decides as to which of the vendors would provide the end customers.
Okay.
That is the gist of the matter. Your
Lordship has already likely pinpointed out that page 47 annexure 8. Lordship, that is in fact a proposal, Lordship. A proposal given. In fact, he was admittedly our business associate, which we wish to engage his service for another 6 months till December 2023. Accordingly, we give him a proposal that he need to accept the same terms and conditions of his earlier engagement and also show his confirmation of interest. There are two terms, Lordship, in annexure 47, Lordship. Page 47, Lordship. He need to accept the terms and conditions of his earlier engagement and also show his confirmation of interest. Lordship, in fact, he never confirmed his interest, nor he accepted the same terms and conditions of his earlier engagement. Rather, Lordship, by the two annexure, which my learned friend has now relied on, that annexure, that is at page 48 and 49, Lordship.
Yes.
In fact, by this, he sought for further additional information. It cannot be treated as a confirmation of interest. Lordship, what he sought for? He sought for, Lordship, if Lordship takes to annexure I at page 48, Lordship. May I just read the contents,
Yes.
Sir, with reference to the above mentioned letter, it is to inform you that we have fulfilled the criteria to be empaneled as business associates for the segment, namely pesticides and chemical. In this contents, we request you kindly to provide us the detail of item included in the said segment for which you have empaneled us as business associates. Hope you will oblige the above and do the needful from your end as early as possible. In fact, he wishes us to give the details of segment of for pesticides and chemical for which we intend to engage him. And then Lordship, by other annexure at page I, that page 49, Your Honor, he sought for further information. May I just read the contents, Your Honor? Sir, with reference to the above mentioned letter, it is to inform you that we have fulfilled the criteria to be empaneled as business associate for a specific segment, along with few other companies. In this context, we request you kindly to provide us the details of other company who has been empaneled for the same. In fact, by these two letters, he wants us to give us the Your Honor, the details of the pesticides and chemicals for which we wish to engage in, and secondly, the name of the other companies which are also engaged for the same segment. And accordingly, Your Honor, we have responded to him by Annexure J on page 50. That there was never, Lordship, a letter of intent from his part, Your Honor. May I just read the content, Your Honor? Please note that as per our given, your extension in Neramic letter, IBID for extension of empanelment as business associate, no acknowledgement mentioned your interest in the same has been received as clearly mentioned in the letter. Accordingly, your extension with Neramic is null and void. The second portion, Your Honor, we have given him the details of information which he has sought for, Your Honor. What are the items that are included in pesticides and chemical? There are 4 contents of that, and at paragraph 5, we have given the details of the company, Your Honor, which are also empaneled with the Neramic for the same. In fact, it's a proposal, Your Honor. There was never, Your Honor, acceptance on his behalf with regard to the proposal. A proposal should be accepted. Only then it can be termed as a contract.
Mr. Das, I your subject matter it has helped the extension of rendered null and void. But at the same time, other part that in paragraph 4 and 5 also gives the details. So the information which he asked was not a classified information. Your action in divulging the details would go into show that this is a very normal kind of a, not something classified or which would affect their company. Don't think that before you hold the extension or declare the extension in null and void, you have asked for a.
In fact, time is the essence of contract. He need to communicate us because his engagement is only till December 2023 for a period
He
of
is
6
not the only person who's empaneled.
Lordship,
You can get the job done through somebody. Empanelment
that's
is only a base which he is given from which he can be picked up.
Lordship.
It's not necessary that an empaneled contractor will be given
That he will be
every
given.
job. He will take his place in the empaneled amongst the empaneled contractors.
I leave to your
Mr.
Lordship
Chaudhary.
discretion, Your Honor.
You are the agriculture part.
Yes.
Yes, what is what you have contract?
Not on contract, Your Lordship, but the meaning, Your Lordship, that appears to be so. Your Lordship, I've in the list of books, 1970, 2 SCC, 780.
1970
2 SCC,
780.
780, Your Lordship.
Name?
A. Abbas, versus the Union of India and Andhra. Here, the subject matter is regarding construction, and the construction and meaning, Your Lordship, and how to interpret. That is what the intention is, Your Lordship, because I'm basing my submission on the letter of extension. Paragraph 46 is to be precise, Your Lordship. Paragraph number 46 at page 799. If I am permitted to read, Your Lordship. Yes. 46. The real rule is that if law is vague or appears to be so, the court must try to construe it as far as may be, and language permitting, the construction sought to be placed on it must be in accordance with the intention of the legislator. Thus, if the law is open to diverse construction, that construction which accords the best with the intention of the legislature and advances the purpose of legislation is to be preferred. Where, however, the law admits of no such constructions and the persons applying it are in a boundless sea of uncertainty, and the law prima facie takes away a guaranteed freedom, the law must be held to offend the Constitution as was done in the case of so and so. This is not application of the doctrine of due process. The invalidity arises from the probability of the misuse of the law to the detriment of the individual. If possible, the court, instead of striking down the law, may itself draw the line of demarcation where possible, but this effort should be sparingly made and only in the clearest of cases. This is pertaining to the construction of the letter of extension which is at page 46. Page 46, Your Lordship, I based my case law on the basic line which is at subclause 3, which is you may please acknowledge the letter and confirm your interest in the same. My rights had improved, Your Lordship, as a business associate based on my past performance, which led to issuance of the letter of extension.
The extension is not a matter of right. The extension is not a matter. Your employment was for 1 year.
Yes.
It is their prerogative to grant you an extension
or not.
And after exercise their prerogative when giving you the offer,
yes,
they make it very clear that you have to acknowledge and confirm.
Yes.
You may not be interested in an extension.
I may not be. I may not be. In fact, Your Lordship had raised a very pertinent query.
Now, if your case was that you had not received this letter,
then there would have been
matter would have been different. Then also,
yes,
something else would have come. How was the letter sent, dispatched to you?
Yes.
Was it in their hands?
Yes.
Put the whole case of just that moment it is dispatched,
yes,
the offer being complete. Now, offer has been signed after your 2 letters, which also does about outcome.
Yes.
You acknowledge.
I acknowledge.
Acknowledge.
Yes.
17 is a part of the letter.
Yes. Yes. Yes.
That letter you have acknowledged, but you have not confirmed that yes, I am governing us for the extended period of 6 months. You ask for some detail.
Yes.
Now, we may go into, may not go into the aspect what you are asking
yes,
for.
Yes. Yes.
Whether those would amount to imposing some new conditions in your employment,
yes,
or whether your asking of those institutions will not make any change in the terms of the employment. If it doesn't make any change in terms, they will now perhaps not suffer implicitly because you are not asking for anything else.
I'm not asking for anything.
You ask for something which, in fact, has been divulged to you later on. That means
yes,
we have already discussed that these are not classified.
In fact, if your lordship is very correct. If your lordship can kindly come to page 49, the last 2 sentences, if I may permit to read, your lordship. 49, your lordship. We hereby request you to rectify the same rectification of the website of Neramac, which was inaccessible to the client at your end at the earliest, so that we can avail the benefit of the same. The benefit that the petitioners are espousing here is the benefit of being an impaneled business associate. Nothing else, your lordship.
How does it help you?
In fact, the construction of the term "you please may acknowledge," I'm focusing my entire case, your lordship, on the basic premise that my acknowledgement was not mandated, was not obligated, was not directed by the authorities. In fact, your lordship has also pointed out, clarified that there was,
What about the word confirmation?
I
The
was,
expression confirmation.
yes, in fact,
Confirmation will definitely need an assertive action from,
yes,
cannot confirm by sitting up.
yes, 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 your lordship is very,
Acknowledge, okay, by replying to that letter in a different context, asking for some details and
Yes.
giving reference,
Yes.
that amount to acknowledge, yes, we have acknowledged
Yes.
that, it's okay that.
Yes.
The expression there too, that offer letter. The last paragraph you're trying
yes,
to read, and it comes that
page 47, your lord.
page 47, the
Yes.
last.
Yes.
You may please acknowledge the letter.
Yes.
And.
Yes. Yes.
Then.
Yes.
Two parts. One
Yes.
is acknowledgement and confirm your interest.
Interesting.
Your acknowledgement itself will not do.
Yes.
Not all.
Yes.
Both will have to be present. Your letters which have been issued to them.
Yes.
On 17 those may amount to acknowledgement of the receipt.
Yes.
May acknowledge this letter, receipt of this letter of offer of 30, but that may not be construed to be a confirmation extension of.
Yes.
This which perhaps the just hard.
Yes. This is what my learned friend is saying, that our initial, the subsequent two correspondence. Yes, in fact, your lordship, your lordship is very correct. I had mistakenly focused my case law research on a different aspect of it. But the matter here which persists for your lordship.
Do you have any case law to your intention? Right of letter also amount of confirmation of the offer, because you have not changed the conditions of the letter. Because
No, your lord, I do not have on that line.
this is continuing. This supply thing is continuing.
Supply lot they are continuing, but to other your honor.
But no, the job is continuing. They will allow this, but for a period of 6 months thereafter, prerogative of the upon whether you want to offer, whether you to. We cannot say anything about extension. We will not even say you to offer an extension. But this 6 months
till December.
Till December.
2023.
December is the last
December
remaining.
2023.
December will not, that's not just 6 months date of verification.
Lordship, otherwise, Lordship, by that annexure 47, page 47, it's his period, his extension was only till December 2023. May I just read, Lordship, page 47, Your Honor?
How do you overcome this? December you will get the 1 month.
Only till
Okay,
that.
we'll just
If I may be considered.
Third.
Yes.
Yeah. We neither some for some for
Yes. If the lordship permit me, your lordship, I can.
no question of permitting. Third preemptive for petition also heard. We need a number.
Respondent number 3 and 4, Lordship.
3 and North Eastern Regional Agricultural Market for Naramic. Union of India. RD whereas number dash the agriculture department represented by each of the subject called and that actually has been filed with contest this was what's your first line paragraph on what to
petition number one. Yes.
The petition number one, the private company, whereas the petition number two is one of the directors. The petitioners operate the field of trade and supply of seeds, pesticides, fertilizer, and other agricultural goods to different agencies, including the government of Assam, and to different agencies of the government. The question number three, hereinafter called, not hereinafter called NRM, had floated a notice on 13/5, whereby expression of it was solicited for being empaneled under the state corporation as a business. In the case of the petitioners that their offer was empaneled, and by letter dated 30/62, the petitioner number one was empaneled as a business associate for one. The case of the petition that their performance was satisfactory, and based upon based upon a letter was issued on 30/6/2022 to the petition by the number three, whereby the empanelment was extended for a period of 6 months, 31/12/20, on its term and conditions. The letter, however, directs the petition to acknowledge it and confirm their interest. Sharma, the learned counsel for the petitioner, has, however, submitted that though the petitioner did not issue any letter which expressly contained the issue of confirmed, two letters were issued by the petitioner, both dated 17, which have been annexed. By the first letter, the petitioners had asked for providing details of the item included in the segment for which the petitioner number one was embedded as a business certificate. But by the second letter, the same date, a request was made to provide the details of the other companies who were also employed
Same category.
for the same. The petitioners had also informed that the website of Neramex, soon the site of the Neramex, was not being able to be explored for the last month, according to steps were directed. The demands of the petition is, however, with regard to communication 23 issued by the NRF, whereby the petitioners have been informed that the extension NRF to null and void. The reason for action has been to be that no acknowledgement mentioning this was given by the petition. The issued letter, however, revealed both the information sought for by the petition, their communication date 78 the Dharma Learned Council has sub that the part of the letter whereby extension has held null and void is unsustainable in law on the following grounds. So, the if the offer, the letter dated 36/2020 of empanelment was a decision already conveyed by the NRMX, and the confirmation of the acknowledgement of the same would not make any material difference. Number two, even if the letter dated 30/2020 is held to be an offer, the same was not bound by any time for which the acknowledgement has to be made. And in any case, letters were issued by the petitioner. Two letters were issued by the petitioner on 17/8, much before the impugned communication dated 28 was. Both the letters dated 17/8 refers to the communication 36/2020.
Yes.
We have not that letter 2022, not 20.
Yes, Your Lordship, because we were initially impaneled by 2022, and that was
we
the
have not,
reference.
that letter is, we have not mentioned that.
Yes, Your Lordship, that substantiates the fact that the petitioners were in the knowledge that they had already been impaneled and confirmed.
Empanel, no, you are working.
They're already confirmed, Your Lord.
You're working for 1 year, but
Yes.
thought you had did you receive the letter or not?
Yes, we received the letter. We received the letter on time.
Why did you make a reference to that letter? We thought this was 36/2023.
No,
It is 2022.
2022 year.
Um, at no point of time the petitioners had expressed their inability to continue with the extension and had rather sought certain details which should not affect terms and conditions of that empanelment. Para. Support of the sub. Of the above report directly of the does of that construction of expression of such a manner which is towards
The best, the best intention.
paragraph 40.
Yes.
Which would pass he does come for contest content number submit that the letter is 36 submit that extension of the amendment is not a matter of right, as the initial notice dated 13/5/2020 seeking expression of interest was only for 1 year. He accordingly that the letter dated 36/2020 can address the term to be a letter of offer, which was required not only to be acknowledged but also to be confirmed. It submitted that the state letter makes it specific that the extension proposed for another 6 months were on same terms and conditions, and therefore it was necessary to have the confirmation on record. He further submitted that both the letters 78 2020 heavily relied upon by the petition cannot be considered to be letters of acknowledged, as there was no reference to the offer letter of 36 2020, and therefore the impugned order dated 23/8 is fully justified, as the requirement of supply was of immense public. Both the features standing on agriculture part and the state children submit that is with the corporation, and they would not have much say. The tribal submission material is have calculated. The initial empanelment of the petition by communication dated 30 was for a period of 1 year. The materials on record would show that the performance of the was expected, and this conclusion of the is fortified by issuance of the letter dated 36 by the corporation, which has by which it has been stated that considering the performance petition number 1, the last year after the empanelment as a business associate, the empanelment was extended for another period of 6 months till 31/12 on same terms and conditions. This court has, however, noticed that there was a requirement to acknowledge the letter and confirm their interest. Though much emphasis has been laid by the counsel for the on the two communications 78, this court of the view that both the communications can neither be treated the acknowledgement of the of it, nor of confirmation of the decision. This is because of the fact that there is no reference to the letter 36. However, at the same time, this court has observed that in the impugned letter dated 23/8 by which the extension offered has been termed null and void, both the information sought for have been revealed, has been divulged by the corporation to the meaning thereby that the information sought was not classified in any manner. The letter of 70, one of the letters 70 has also raised that the side of Nara was not being able to be explored and kept it at for rectification of Nara. The a close perusal of the letter dated 30 by which and I would show that though the letter was directed to be acknowledged and confirmed, the extension, the decision to extend was already taken by the corporation, respondent number 3 corporation. Under those circumstances, holding such extension to be null and void without seeking any further petition does not appear in as much as more when there was no complaint regarding in period of imprisonment of one preceding after the offer letter, after the imprisonment letter dated 30. In fact, the letter dated 36/2023 has issued only based on the performance of the petitioner in the previous year of their imprisonment as in view of the learned counsel has also clarified that petitioners are very much to contribute with their imprisonment with the respondent corporation, and the empanelment full stop. This court has also observed that the petitioners are only seeking enforcement of their extension of empanelment, which would not mean that the petitioner are to be given the business as a matter of right and would only be within the zone of consideration for allotment of such business. And in view of the above, court of the opinion that a case for interest and according to the part of the order stated impute communication that 28 by which the extension of section number 1 has been null and void is bad. The petitioner's amendment according to the next till the date fixed is 31/12. It is further made clear that in the event the respondent corporation is of the opinion that further extension would may be required of the empaneled entities from such offer may also be given to the petitioner. Without the extension.
Right, Your Honor. My lord, the Contractors Association of Police Housing Corporation, my lord, they are before
Even
your
also
lordship.
before started my senior star also, they have filed an affidavit in reply also in our affidavit. They have filed on Friday. My friend says that it is not in our record. Even honorable court record also is not.
It has been brought to the record
No, then lordship may on
after tomorrow.
on 30 lord. Day after tomorrow.
PMK should return. Submit and reply with right. Court has also that on a therefore such as agreement for three that there are getting us
Additional senior government
not for but
lordship.
how for some as some that on
30 lordship.
healthy.
Well, the interim order is still today only.
About the past
Obliged.
Maybe. This will regarding settlement of market Millard. And record was called for, record has come and Mr. Chaudhary was also preparing Millard. Yes, come. The fact is very simple. Fact is very simple, Millard. NIT was issued, well, I have submitted tender.
Ready for the other side, ready for the matter.
Mr. Chaudhary was there, Millard. Last year before the item, Millard.
Be chosen.
My lord.
Be the
My lord.
act tester of RT for what the matter?
Matter, Millard. Here, Millard, I am the owner of tender, Millard. Tender government bill was Millard 1,26,420, and my bid was Millard rupees 3,100,001. And the respondent number 6 who was settled with the market Millard, his bid is Millard rupees 2,52,000
838.
That's it. That's
This,
it.
my lord.
That's it.
No, yes, sir. And now the question is, my lord, here there is a condition of tender that original land patta of the land paper should be submitted. But what I did, my lord, I have submitted the photostat copy, but I have submitted the whole amount, my lord. On the case.
That will not be enough. Your submission of original records or documents are
Yes, that is
necessary.
regard. But only my submission will on this point, my lord. I am to submit the original document for what? That is for the purpose of security. And security, I have given all amount, my lord. By demand draft, my lord. That is also in CS that is mentioned. They have also accepted the same, my lord. I am to submit the some paper, some security for the purpose of security of that if I fail to pay. But when I paid me the whole amount on the first day, then what is the security is required, my lord? Only that is the case, my lord.
No, we would do away with the requirement of original papers. Is it the only security which is the subject matter? Your antecedents, who are you? Anyone comes from anywhere, gives all the money, will you get the tender?
No, I have submitted tender validly. I also submitted photostat copies. Other documents
your
I have submitted.
antecedents as a competitor. It's not only a question of money. Your antecedents, who are you? Do you have landed properties here?
I have photostat copy. I have submitted. Even though I have not submitted, I have
Having the giving the money is not the only. Then in that case, there was not been a requirement of any papers.
Yes.
Give the money.
And other documents, I have submitted all this, my lord, as per requirement.
What documents?
That is, my lord, as per condition with the NIT, my lord, I have submitted. Only that left is there, my lord.
I don't think that be a directed requirement. Money is one of the main essential conditions. Along with money, other conditions are also there. Why can't you give your original? What is the difficulty?
Actually, there is a fault.
No, what is the? Do you have the original or not?
At present, I have, my lord.
Why did you give?
That is the wrong understanding of the parties, my lord.
Right now, do you have the?
I have with my lord, I have no, but party with party.
No, not only I'm not but you as a counsel.
Yes, my lord, I have.
Does your client have the original?
Yes, I have. I have, my lord. If your lordship says tomorrow is to produce, my lord, I can produce your lordship. All are required documents.
Okay, but all the counsel.
My lord, then all 5 minutes later, I'm calling him, my lord. After 5 minutes.
Yes.
Idea your lordship rejected, madam. My only question, my lord, the petitioner admitted he is the owner of the vehicle. But there is no other involvement. Section 13(1), whatever this offence is alleged, my lord. And I might have subject to what your lordship has seen already, my lord. But here, my question, your lordship is rejected, saying that he is the owner of that much, my lord. My question, my lord, I have given a higher, my lord. And that person was there, my lord, and ultimately he was found to be that also, my lord, and there.
What are your new grounds?
My lord?
What are your new grounds?
Yes, your lord, kindly say paragraph 8, my lord, page 6.
Paragraph 8.
It's 6, Oh, sorry, madam. Page 6, paragraph, page 8, my lord. A, my lord. Paragraph 8. When the vehicle as well as the cattle seized by the police information on 11/8, petitioner approached before the police several occasions and stated that he is totally unaware about the cattle and he is no way involved. And hence he asked the police to release his vehicle, keeping the cattle, but the police person, though initially agreed to release the vehicle, but later on petitioner came to know that on 30/11, after 3-4 months, 3 months, FIR was lodged. Has been lodged against the petitioner. Petitioner also disclosed the name and address of the driver who committed the offense. By cooperating the institution of the case. Once already he appeared 2 times fine. Then your lordship will find that she also.
It cannot be new ground.
New ground, my only involvement, my only question, whether your lordship may see the kind of papers of my land and say whether any involvement is there other than ownership. Simple, my lord, I am the owner of the vehicle, I cannot be held liable. This is my case. Only your lordship will see, my lord, whether I have.
No, you
I
said
had
that
any knowledge on
in paragraph A, you have said that you came to know on 30/11/2023, but the FIR was lodged on 30/8/12.
no 30/11/23, my lord.
You are knowing of the, there is
FIR,
no delay in lodging the FIR.
no, FIR is, FIR is,
FIR 30th of August.
yes, that we came to know on 30, that is.
You
So,
are knowing of the FIR. will
so
not make
11,
if
8
you
and
could have made out a case that FIR was lodged last month.
my lord,
after the-
11, 8 and 38, my lord, you kindly see, my lord. It is not my short period, my lord. You have seized it.
You are harping upon that came on 30/11.
Yeah,
30/11.
I came to know, but I have gone several times before the police. Several times, my lord. At no point of time, police say that he was involved. I have gone to take my vehicle there, my
When did your father expire?
father expired, your lordship will find. That is,
A long time back. These are not new grounds.
that only because of the, I left the study, I couldn't, my lord, I passed higher.
These are not new grounds.
No, that's my only your lordship see my subsequently whether my involvement has been found or not, finally or something is there, my lord. That is the only thing.
We are
I am the owner, my lord. Nobody, I am not denying that your
our role in adjudication of an application for 30 and that too in a second case.
my
Bail application, regular matters are there. You have put two grounds.
my lord, my only question whether they have found me anything, anyway, what actually who said about my involvement. That only your lordship see.
That will amount to again merit of case we have already decided.
The merit part is subsequent development your lordship may see, my lord.
Lordship,
After the passing,
yes, Lordship, earlier it is rejected on 19/10/2023, Lordship.
Yes.
And Lordship, whenever I have gone through the city, it is updated up to 13/10/2023. Lordship, in this required, it requires to be updated. City is required to be updated.
1310,
13/10.
1310.
13/10.
Before the last order.
Before the last. Yes, Lordship.
So that's done, but not much. Which this is
Lordship, it is Bullockganj.
Bullockganj. When can you get the CDR? CD is with you.
CD is with me, Lordship, but that is
Send
not
back the
updated, Lordship. Yes.
What are the status of it?
The investigation is Lordship as because
No,
during
that was up to 1310. Do you have any other information there?
no, Lordship, that I have.
Let him have the
Yes.
What is your
Lordship K. Bushka.
thought? The cable is however, subject to the case that has been procured by him. The same update till 13/10/2020 and the last order by became fair for bail of the petition was taken of 9/10/2020. Alternative record of carrying support carry is the update of the concept where is direct on
Lordship 14/12.
send it immediately.
Yes, yes, yes.
To enable is alternative have is area.
Oblige.
Yes, come. Oh yes.
Lordship, I have the record. It reveals that the competitive chart, Lordship, petitioner did not give original land document. Thereof.
That is the case he has picked. And he was making a that's the offer which he had made deposited in standard. So it will not make any much difference because mainly for the purpose. But we have not accepted that way, because it's not only the purpose of having the money, it's also for the who is has got an and without the original paper, and that satisfaction you may not have. But on a subsequent query, it says that the original papers are with you, can be furnished to you immediately.
Lordship, let the authority decide.
But that again not entirely. We don't want extension of market. We did give it to the authority. Any decision taken by the authority cannot.
Yes.
Your purpose to ensure that you are satisfied not only about the price but also about the who is.
Yes.
Vendors cannot come to say that I am giving the entire price. Give it. Not.
Yes, Lord.
All other conditions are equally important.
No,
He says that due to some inadvertence, the origin could not be submitted, but he has the origin.
other certificates, Milord, where there is a certificate. Just like Milord, there is a PAN card or Aadhaar card, GST, and all this I have not submitted. Only there is land patta there is I could. Percentage was submitted, but not.
How
the
much is the tenure?
1 year.
1 year, Lordship.
When was it floated?
It was floated on the 24th of May, 24/5/2023.
And
And
now
what-
who's running?
And the
Lordship,
respondent not sick.
respondent number 6,
Is he
approval.
there?
No, he is not. He is served Milord. As per office note Milord, he is served.
And
And he
Lordship,
has he has no contact. not contact.
approval was given on 3rd of July with effect from 1st.
What's the difference price?
About 50,000. About 50,000.
50,000.
Right.
How much?
Tender government bid was Milord 1,26,428.
Government value
1,26,420.
126,420
420. And my
for
bid,
1 year.
1 year. And my bid was Milord 3,01,001.
1 year. And R6
R6 Milord 2,52,000.
2
252
52
838.
almost 50,000.
All
Yes.
about.
Where's the order by private company?
Kindly Milord order dated Milord 8/9 office note Milord. Office note 8/9/23.
Order 29 days order.
8/9/23. There is
29 days of order. 29 days of food test
service complete. The office note is there. For only honorable justice.
we give the description. Other
Yes.
your form, madam. Your form. Or the receipt for petition. Also heard.
For 2, 3, and 5.
Standing on whereas 3 Biswas, 56, portfolio state council and 3 Biswas council appearing instruction of S. Dr. State Council C and R. Council subject and also term of concern that is for one of district at the admission. Please have your and a night was
Peaceful,
floated
peaceful.
on 24/5/2020 for settlement of cash by week market for the year 2020-24 in the district of Baksa. The government value was given with is 1,20,40. The bid offered by the petition was 3,01,001, whereas the bid of the respondent was 6 was 2,8. The petitioner, however, is aggrieved by the action of respondent by which the settlement of the market question has to the respondent number 6. The the proceed demanded counsel for the petition that in matters of distribution of theaters which parties matching of the highest of would be the amount offered would be of relevant consideration. And in this case, there is a vast difference with the offer made by the petitioner and the respondent. On the other hand, the Chaudhary, the learned standing on the petition, has submitted that though the offer made by is was the highest and more than that of the respondent, the comparative statement would itself reveal that the petitioner did not submit the original land documents, namely the which is a mandatory requirement. The understanding council according to submit that the decision to offer settlement question to the respondent cannot be faulted, as the petition had did not fulfill a mandatory requirement. The Pokolial, the United States Council, NMS, Viswas, Current Council for the Department, endorsed the submission of that joining his submission, the United Council for the petition that the student action is not sustainable because of the fact that the offer made by the petition was actually fulfilled as the petitioner had deposited the entire amount by way of demand draft, would further that the requirement of submit original land document is only as a matter of dispute, and since the petition had deposited the entire offered amount, such requirement has some redundant. Para. The rivals have been duly considered and the materials would have carefully done. The projection made by the petitioner that the offer made by him with regard to appear of this court had ordered 29 had observed that the appears that the respondent was not to contest. The projection made by the petitioner is that his offer being the highest common grant of settlement of market to such a normal was that the intent, the reason which appears from the record as well as the competition that the petitioner did not submit original land of full per the Jamaban. The requirement of submitting original land of is a mandatory requirement, and the mandatory requirement which cannot be done away. Submission made by Senate Council for the petition that that such requirement is has become redundant view of the fact that the petition had deposited the entire amount by way of demand draft is not liable except by the court, as much as it is not only question of amount offered by a party, but is antecedent and other factors which are also examined. The authorities cannot be left with no option to make the selection of best person whose offer is also viable as well as is are known. In view of the above, that the reason for the impute act cannot be found false, and according to it is this at this stage we received learned counsel on a pointed query from the court as submitted that the original documents are in his possession, and it is only viewed but at the photocopy of the state where present along with in view of such submission while the petitioner is good to approve the appropriate authority by renewing his offer and submit the original land document which is if such application filed by following conditions mentioned above, the EC may consider according to more substantially of the fact that the offer of petition is more than the that of the by almost the same. But
The authorities shall consider, my lord, that document is within 10 days.
since since the tenure of settlement of 1 month in the event the application as mentioned above is subject such with a period of 15 days from the
Right.
But I'm taking review of your lordship judgment because the rule was not produced before your lordship. And as per the rule, my lord, Secretary Village Defence Committee, it is a, my lord, nominated. It is not an elected. So therefore, my lord, your lordship's order is liable to be reviewed. Because your lordship said that is
not a or
no. The rule is very clear, my lord, page 86. It says president will be elected, but secretary.
No, no, rule was there. Others it to be in record. WBC.
that's what the
Page 86, my lord.
of your review.
Yes.
It's
5, rule 5. Yes, page 86. It starts from page 85.
Yes.
The Assam Village Defence Organization
Rule 5.
Rules 1986.
Yes, rule 5.
Rule 5A, my lord, last two sentences. The member of the primary committee shall select the president by majority opinion.
Yes.
And the secretary of the committee will be nominated by the district village defense officer from amongst the primary committee members.
You are a primary committee member, otherwise.
Yes, yes.
You were nominated by the
Yes, yes. My lord, and
the question of
the
election will not
affidavit filed by the that officer, your lordship will kindly see at page 75. Page 75. It says public meeting recommended both, and I have. And may I read that paragraph
Page?
7, page 75. Page 75, paragraph 7, last sentence.
Yes.
I'll read, my lord. Accordingly, a public meeting in Durga Mart 27 to 22 under the presidency of the so-and-so level committee. In the meeting, the president, Shri so-and-so Sarkar, resigned from his post along with Nick, Mr. Kakar Sarkar and other members of the Durgapari VDP. Because 5 years term over, he was continuing with 6 years. The 6 years, in fact, he served for 6 years. Thereafter, the meeting decided to recommend two names, namely Naushad Ali and Mohammad Pyari Ali for the post of secretary.
You are Pyari Ali.
I'm my lord Pyari Ali.
Here.
Pyari Ali for the post of secretary Durgamari VDP. The names of the meeting with the recommendations from the Pope and the officer in charge of the so had been received and used. Based on the recommendations and after considering the tenure of the present committee, the deponent in the capacity of the DVDO approved the names of new president Mohammad Azizul Haq, Nek, so-and-so, and secretary Pyari Ali for Durgamari VDP. The deponent exercised the power bestowed under the provisions of Rule 9 of Rule number 19 of the Assam Village Defence Organization Rules 1986, wherein it is stated that the tenure of all committee formed under these rules shall be for a period of 5 years from the date of formation of each committee. On expiry of the terms, each committee shall be reconstituted as provided herein before. The old committee, however, shall continue to function till a new committee. Now, your lordship will kindly see that the appointment is made by the my lord SP, who is the competent officer, and that page your lordship can see at page Sir, 54,
5-4.
5-4. But it is not necessary to be elected, my lord. It is to be nominated by the.
My lord, there are many other things I will
Now,
submit.
54, my lord. President Ajiul Haq, Secretary Pierre Ali Sarkar. Approved with effect from 6/4/22 with the following new officials by dissolving. It is not that a committee has it, but it is the power of the, this rule was, I think, my lord, not placed before your lordship. And therefore, my lord, because it is a, to be nominated by the president, by the SP, my lord, who is the competent of.
He did not appear in the writ petition.
My lord, I did not get notice from the High Court. Though they said, my lord, thought that controversy I am not going. Because
No,
though they said, my lord, they have
it's serious
started copy
matter.
to us.
Trustee was there.
Trustee was there, but I did not say, my lord, I did not
That's
get
why, my
it.
lord,
And I did not get a copy of the writ petition from the High Court. So that is what I have stated in the petition, my lord.
page 9.
Paragraph
3, page 9.
Paragraph 9.
No.
Although he was impleaded as respondent number 5 in the writ petition, but he could not appear and participate in the writ proceeding as he did not receive any notice from the
Paragraph?
Honorable Court. Paragraph 3, my lord. Page 8. Although he has impleaded as respondent of 5 in the writ petition, but he could not. The petitioner further respectfully states that recently he came to know that the petitioner has filed an affidavit stating that notice was sought to be served to the present review petitioner, but he refused to accept the same. The said averments of the writ petitioners have been denied by the review petitioner and further reiterated that he has not received any notice from the Honorable. This is the position, my lord. I am not going into all these facts, my lord. I am saying, my lord, the proper appropriate rule was not placed for a lordship, and this is not an elected post. If anything is to be done, it has to be done by the concerned officer, who is at page 86. The secretary of the committee will be nominated by the district village defense officer from amongst the primary committee members. Who says, my lord, if an affidavit is filed? That nominating me, man. Not
in the review.
Oh, that's the advocate third thing. That has not been placed. I'll place. Lordship will give me a place.
And my lord, the original writ petition may be called for because here he entered his first word, but at that time some mysterious telephone came and he did not sign it.
Where?
So, the original writ petition in Justice Service, He wanted, Pierre Ali Sarkar, he wanted to write peace sin. But at that time, some phone came, he did not accept the notice after reading, and the persons who went with the writ petitioner, they have given also their phone number. Here are two things, my lord.
Okay, wait.
Either he has
First, let it be
filed
placed.
the false affidavit, or we have filed a false affidavit. There must be consequence.
Okay,
So
wait.
SP may be directed to inquire the matter, how he has shown a false affidavit before the Honorable High Court. If my party has said anything wrong, they will also face consequences.
It is a specific counsel for the whereas opposite party court has however that the right of record what is in a council raise run week time to
Next week I'll.
for a week's time to compare
Along with
Next week.
WBC.
WBC will have.
No. In WBC, Justice Services, there his signature is also there.
We have just WPC already.
No, my lord. In the original writ petition,
We
filed-
have the original petition.
Oh yes, my lord. Sorry, my lord.
We repeat everything. We are not talking about the annexes to the review. We are talking about the original petition we have.
Next week.
After
Apply.
Madam, your matter, other side is there.
But, I contacted him, and my information is that, my lord, the file has taken out from Learned Council, my lord.
Who was that?
P. Nandi, my lord.
Opinion.
P. Nandi, my
No
lord.
longer here.
Yes, my lord. And now, right now, his phone is switched off, my lord. In the morning hour.
We'll do one thing. Give a chance for only one. Will be record that they are
Yes. Yes. Two. Sorry, my lord. Please. Oh, yes, my lord. With whom I have fun. Peace and Egusan.
Okay. Order of order.
Apply.
Yes.
May it please your lordship. Lordship, as per last order, my lord, 10/11/2023, I was directed to take step upon respondent number 4 through sending council, my lord, environment and forest. And I was accordingly took the step.
Lordship, we have written a letter to the PCs here to forward this petition to the
Four is, my lord, state level impact assessment authority.
Lordship, it's the government of India
Oh, it's
entity.
the government first. This can appear.
Yes, Lordship.
If the
Apparently,
This is
it
under
is
the
a
Ministry of Environment, isn't it?
Yes, yes.
Can appear. Now, what is the response?
Lordship, we are waiting for instruction.
Unconnected, it's supposed to be reflected.
No, my lord, it's not in respect.
But I'm not sure.
Yes, yes.
Now, who referred to the order that can 11 passed by with regard to service of upon the response report to forest department of Sarah, the High Court of Council represent forest department has up in terms of direction of the this has been with forest department to the which however get to that court has noticed that the state level.
Yes,
State level is under the Ministry of Environment.
It is constituted by Union Minister of Environment.
Where is any papers relating to
My lord, there is no such any term.
no, anything, any communication.
Communication, my lord, lordship will find it, my lord.
This court is informed that court, which is the is constituted by Commission government. That this is on Biden act, huh? by the name of this because let us see if something can tell about the past the next
Obliged.
Yes.
This limit, no, your honor. It's not, in fact, just due to some confusion that made.
Not
a
They're appearing for that.
I appearing for the response number 2. Now, my lord, yeah. Lord, you may kindly look into our affidavit, paragraph 6 and 7. We have.
Mr. Roy be appearing.
He cannot appear today, your lord, due to personal difficulties, your lord. Can be on next
Because my client has already,
Thursday, your lord.
my lord, retired from this service. In 18, he was 57. Now it is 23, my.
What were we doing?
He was an officer in charge of a police, of that particular police station. He has relinquished a charge on 2015, and thereafter he retired by now 62.
But what was the
nature of context, my lord? There is an order passed by this honorable court. It is an absolutely private dispute between them and the private respondent number 1. So, my lord, status order was filed. Then, my lord,
did not take care for.
no, my lord, their allegation is that, my lord, despite of passing of the status quo order, the respondent number 1, the private respondent, encroach upon the land. So they have filed an FIR before us. So we take an action, we file charge sheet also, my against it. Yes, I am against me, my lord. Lordship may kindly look into for timing paragraph 7 and 8.
You have to take whether it is one has appeared. What has appeared?
Lordship, I'm not very aware of the lordship. So time may be given for Thursday, your lord.
Okay, day after tomorrow.
No.
Compare the
Obliged.
Their pressure. Yeah.
Obliged. Obliged.
What about the?
Yes.
Concept.
Yes.
First one. R1.
My lord, R1 is a
R1 is the particular.
yes, yes, yes. It is my lord privately a dispute of the civil nature, my lord.
That cannot.
Yes, my
Cannot.
yes,
That we set an order. But
yes,
whether this order is correctly passed or not, that's not the question.
yes,
for us.
my
Neither you can. You can
yes,
we have to, whether the order is still complied with.
yes. Because they say they after status quo order, they started immediately. We go on and stop the construction, and with my lord file.
Have the response file.
Respondent number file an affidavit, my lord.
Okay, they have to.
Yes, yes.
I'm sorry, my lord. Item number 6, my lord, has given a date on 30/11, my lord. This case, my lord, we are late by learned senior counsel PKTR, my lord. His mother is admitted in the hospital. Kindly accommodate a date after 8th of December, my lord. Any date. After 8th December, kindly date maybe quick, my lord.
It's not.
12. Well,
Obliged,